Okay, great. I think we can slowly start. So hello all, and thank you for joining to SCL Turkey's webinar today. Inflation in the international construction projects, risks and solutions. My name is Başar Şahin. I'm a board member at SCL Turkey. I will be the moderator today. So following the pandemic and then the Russia-Ukraine war, inflation globally has been in very unusually high levels, and that results in increased prices for construction costs. Global construction markets and its usual players, contractors, employers, financial institutions, suppliers, have to deal with this new era and learn to work in a work environment with inflation. So this new market dynamic brings new rules to the industry, and the related risks need to be carefully considered by the parties to construction contracts. Today, as Society of Construction Law Turkey, we will talk about inflation and what the parties need to do looking at the future. We will have about 45 minutes to 1 hour for the panel discussions, and we can take questions thereafter. I see we have over 100 attendees in the webinar today, and that number also shows the importance of today's topic. So before I introduce our panelists, I would like to first sincerely thank our sponsor, CCI, for assisting SCL organizing this event today. So today we have speakers from the legal and claims industry, Mr. Julian Jones, Managing Director, Middle East and Asia at CCI, currently based in Dubai, and Amir Ghaffari, Managing Partner at Ghaffari and Partners, also based in Dubai, and Robert Stephen, Chief Operating Officer, also at Ghaffari and Partners. So thank you for coming and joining us today. I would like to give the word today first to Julian and see his views on the topic. Julian, so where do you see the construction industry is heading with regards to inflation risks, and what are you currently seeing in the market at present? Julian, please.
Okay, well, I'm going to bring up some slides to go through this, if that's okay, Bazar. Yes, so I'm just going to do that now. Just bear with me 2 seconds. Sorry. Sorry, just bear with me. I am just trying to find my slides, which I had before. I go down, yeah, scroll down, sorry. Minor tech problem. Oh, there, right at the bottom. Okay, so what I was going to do, if I can just get this out of the way. So hopefully you can all see that. Can you see that, everyone?
Yes, we can.
Yeah. Okay, so just, you know, in order to answer the question, I think I was just going to sort of talk a bit about the background. And I've got some slides here. I'll talk you through it. But basically, I think I've put up here like a look ahead for the next 5 years from inflation swaps in the market. This is up to October 22, which I don't think you can see on your slides, so I would just talk through it. But in order to answer your question, okay, sorry, hang on, let me just see if I can get this. Just having some issues. It's there, but I can't. I don't know. So, I don't think that's being shared. But... Okay, is that it? Okay. Okay, I'll just do it without that, I think. Okay, I was trying to pull some slides in, but it's not working at the moment. Anyway, to answer your question, I think at the moment what I'm seeing is issues across pretty much all industries that we're dealing with. So it's not limited to one particular sector. I'm seeing it in whether it's an oil and gas project, whether it's infrastructure, whether it's construction, traditional construction. We're seeing a rise in costs and labor across the board. And I think this slide that I prepared before just shows you that I don't think inflation is going away anytime soon. I think from my research on the matter and having dealt with it, we haven't seen global inflation like this since about 1982. And that in itself is a challenge because people who have dealt with this from an expert point of view, from a quantum point of view, are more senior in our profession. So at the moment, I have two live issues on my desk with this issue. So in answer to your question, Bazar, I think it's very much a current problem. I don't think it's limited to one industry, and I think it's a global issue. And I think it's here to stay if you look at the graphic up here.
I personally think that's right. This is Robert Stephen, and hopefully you can maybe see the slides that I've shared for Julia. If not, I've tried to share them from my computer, just shouts when you need them changed. But I think that's right. I think, look, undoubtedly, as was correctly said in the introduction, COVID-19 and the geopolitical landscape have been a trigger for inflationary price increases. And what we've heard over the course of the last 2 to 3 years is that mainstream economists have been saying that the current inflation environment is temporary, and that central banks around the world have been essentially forecasting that we would return back to kind of what you would expect after about 2 to 3 years. But I think what we're seeing today, actually, and what is being discussed today, is actually a suggestion that inflation is probably here to stay in most jurisdictions around the world. And actually, they're forecasting this environment to at least kind of 2050. So I think the position has somewhat changed. I think perhaps in the early days of COVID-19, it was perhaps believed to be something that would be temporary and we would get out of it after a 2 to 3 year period. But now, as we've moved into it and lived with it for a period of time, I think the belief is that it's something that's here to stay, and that is reflective of what we're seeing as practitioners in this part of the world. And it's also reflective of the type of work that we are seeing on our desks. You know, Amir currently has a client in Saudi Arabia where this is a very much live issue for that particular client.
All right, so I think we have a problem that will carry with the markets for quite some time looking in the future. So Julian, do you want to carry on about your thinking about the issue?
Yeah, so just working through the slides, I think one of the things I wanted to talk to you about was escalation clauses. This is traditionally how inflation has been dealt with contractually. It's a provision in the contract that calls for adjustments in fees, wages, or other payments to account for fluctuations in cost of raw material or labor, and it shifts the burdens for increasing materials and labor costs from the contractor to the client. So what I'm seeing in the industry and speaking to people is that a lot of employers and operators are trying to deal with this issue. And I think that you'll see more and more escalation clauses like this coming in. And I will talk about it in a bit more detail, but they are complicated, and it's very difficult, to be honest with you, to cover all costs that are related to this issue. You might be able to cover certain aspects, but to cover all the costs related to material and labor increasing due to inflation is incredibly challenging. And I think as we move through the discussion today, I'll highlight some of the key points on this.
Julia, maybe I should say something on escalation clauses.
Certainly.
Before I do, good afternoon, good evening, everyone. It's a pleasure to be here. So escalation clauses, there are two issues looking at it from a very high level perspective. The first is a point of obviousness. Does your contract have an escalation clause? If it doesn't, then any remedy is either contractual by reference to another contractual provision that might allow you as a contractor, say, to seek more money from the owner in the event of price increases, or more typically, it's extra contractual. What does the applicable law, depending on the jurisdiction that bites, allow you to do? Are there remedies at law? And you'll have a distinction when you look at either civil law jurisdictions or common law jurisdictions. The three of us are all based in the UAE, which is a civil law jurisdiction in the main. And certainly in our law firm, we do an awful lot of work, both in the UAE and in Saudi Arabia. So that's the first point. Do you have one? If you don't have one, then the issue is more complicated. But let's say you're at the contractual writing stage. We currently see escalation clauses that sometimes run to 2 to 3 pages or more, because the parties are trying to capture all of the potential scenarios that might give rise to the contractor coming in and saying it wants more money. And that's where you have the tension. The owner, for the most part, will want to push back, keep it limited, not allow for too many ways to increase its cost. And the contractor wants to caveat its, say, lump sum bid by having windows to jump through if prices go up. A little bit later, I'm going to take you through some slides from a UAE perspective, which also will apply to Saudi. But I just wanted to make those two high-level observations about escalation clauses at this stage. Julian, over to you.
All right.
Okay. Okay, Rob, do you want to move on? So I think this is, again, and I'll open it up to Rob and Mia, because I'm sure they will have much to say about drafting escalation clauses. I know they've both got extensive experience of it, and it's challenging for all of us. But I've just put down what to consider and the challenges here. So I think one thing that you all need to be aware of, and I've had this conversation with a couple of clients, is generally it includes increase and decrease. So the mechanism doesn't just go up, it goes down. And that is a risk as a contractor that you need to be aware of. And I think pretty much what we're seeing in inflation at the moment, because it's global, it's generally everything is going up. I don't think you are getting anything coming down. But I have seen on certain projects that you might have procuring from a different part of the world, or you might be pulling labor from a different part of the world, and that can have a counterbalance. So you need to bear that in mind. Which element of the work is subject to escalation? I think, again, because you're dealing with such a hot issue at the moment and it's global, I think you're getting it across the board. But sometimes when you're looking at it and looking at your what you're building, it might be limited to a certain material or certain type of labor or certain thing you're procuring. The breakdown of the element of work is very important. And you really need to think about this in a lot of detail. And this is where it can get very complicated. Even with, for example, steel, there's lots of different parts to a project that will have steel involved, lots of different members. They can vary dramatically on the inflation. So you might find that a certain steel member is 20%, whereas another part of the plant that's built that has steel involved, and because it's a different element, is maybe 200%. So you really need to break down the element of work that you're looking at. This clause will be applicable to, and make sure that you understand the different aspects of inflation on that work. There is relevant indexes and published indices that you can tie it to. Again, you need to really think about where the work is based and what you're doing. If you have an indice that is, for example, in the Middle East based, but you're actually procuring the work from China or from Japan, it won't work, and there will be differences and issues around it. I think as well, another key aspect that you need to consider is what happens if the index is not published. So if you sign up to a certain index and that's going to dictate how the escalation is calculated, and that index is not published, which I have seen happen, then you need some agreement, and you should cover it in the clause about how that's dealt with. Another sort of two aspects that you need to consider in the mechanism is what happens if there's an extension of time? Who's going to take the liability for the escalation, especially when you get into a concurrent delay situation? And then also what happens with varied work, where if the client comes with varied work, is that subject to escalation? How does that work? So these are all key points. And Rob and Amir, I welcome you guys to comment on this, because I'm sure you've got a lot to say about it from your experience as well.
Yeah, I'm happy just to say a couple of kind of high level points. I think what's always really important when considering these clauses is that it's really important to remember that they can be mutually beneficial to both sides of the coin, because they serve to mitigate risk. And so that, I think, is always important when looking at it. It's not just a clause necessarily to serve one of the parties to a construction contract. It's about looking at it as something that can be mutually beneficial. And it can be beneficial in lots of respects, but one obvious one that's often ignored or not really thought about that often is that it can often lead to lower bidding at the tendering process. Because what you actually have is where you have an escalation clause thought about in advance and put into a contract at the right time, you avoid a situation where a contractor may actually be inflating the price to compensate for the uncertainty in the market. And that's what we've seen in this market, is in contracts where clauses are not being agreed or put into contracts, but in a bidding process at this point in time, we're seeing a lot of escalation of pricing because of such uncertain markets that we're in at this point in time, with prices going up so rapidly that what you're finding is actually bid prices are astronomical. And if an escalation clause was actually drafted and thought about and put into the contract and negotiated, you might actually avoid that. And just a high level point in terms of drafting, I think what Julian has said is absolutely right. You know, we need to look at these clauses as bespoke clauses, but with a reasonable allocation of the risk. So we don't need to be talking about clear terms. We need to be thinking about, in particular, the notice requirements, the method, the time frame, and the supporting particulars. So they're kind of the high level points. And I think we can't forget that there are, of course, industry standards that are often very useful and applicable. And in this jurisdiction that we're based in, and very often the industry standards are used in contracts that are being entered into in Saudi Arabia, in the wider Gulf.
Yeah. One point to add here from experience, and mainly from Turkish work environment, as Amir said, in the business today, we see two types of construction contracts that deal with this escalation issue. The first, there are contracts with escalation clauses and a formula in it, but the parties have disputes that the costs calculated as per the formulas are not covering the additional costs. The second option, and also as Amir said, there are contracts which do not have an escalation clause in it, or an escalation clause is in there, but there is no formula arranged for the clause. So, and also the observation was the the market was experiencing such a low inflation right around the COVID time and also before COVID. We were talking about minus inflations in Eurozone. So the parties chose to delete the escalation clause. And now after COVID, suddenly the inflation going up, there are many contracts which do not have any escalation clause in it. So that's part of the problem. Well, Julian, do you want to carry on before maybe we go to the legal aspects a bit more of the issue?
Julian, can I just jump in and say something about the escalation clauses?
Yeah.
Because it's one thing to have an escalation clause, it's another thing not to have one. But fundamentally, this is a supply chain issue, because on any mega project, the ones that we look at in this part of the world, you will find whether it's the valves or some other components come from different parts of the world. And the impact of inflation will alter depending on the source of the materials you're discussing. The facts in play are also critical. It's often overlooked. So let me give you an example of a matter that we've recently worked on. It may well be the case that you have an escalation provision in your contract. But what if, as the contractor, you've delayed in your procurement? And you may have very good reasons. You may have cash flow reasons. You may be looking at the market. There may be a whole host of other things. That delay might, as a matter of the applicable law, prevent you from seeking the price escalation because you have been responsible for that price hike. That's something that we often see when we go into resolve disputes as a record-keeping issue that somehow turns ugly for the contractor. So it's important to keep on top of those things. And ultimately, as a legal matter, and we'll come to the law later, it's essentially a matter of foreseeability. Have you foreseen the hike or not? If there's an argument that you ought to have foreseen it, it might not be reasonable, notwithstanding what your contract says, for you to seek that additional price increase from the employer. So clauses, great, but also need to be wrapped up in the broader scheme of what is actually happening on the ground on the project.
Yeah, I think those are really good points, Amir. And I think the foreseeability argument is an interesting one, given where we are now. I don't know if you've come across that, but I'm guessing that given the fact that this global inflation and is everywhere, it's going to be very difficult to say, well, I didn't really expect this to happen, I would imagine.
Yeah, and what that actually does, Julian, is another thing. It depends on the industry and it depends on the particular material. It sometimes creates a run on the material. Yeah. And clearly a run for or a demand will hike the price up. So it's a bit of a catch-22.
Yeah, and on that, we've seen clients that have actually started to stockpile for particular projects, which of course has an impact in and of itself, because if everyone's going to be stockpiling, then you're going to have a shortage in the market. So, and that, I suppose, is part of something that we can discuss later on, which is practical considerations. What can you do in the circumstances where you're faced with a hyperinflationary environment? There's lots of things to be thinking about and looking at, whether it's putting in escalation clauses into your new contracts, whether it's looking at your dispute resolution mechanisms, whether it's revisiting your insurance, or whether it's just practical things like stockpiling and your ability to do that for certain materials. So we can talk about that in a little bit more detail, but we've certainly seen that, lots of it, particularly in this part of the world, which is probably no surprise.
Yeah. The next thing that's up on the screen is really just how to demonstrate costs. And so as Amir and Robert have said, they're going to talk about entitlement, especially when you don't have an escalation clause. But I think what I'm trying to demonstrate here, and from a cost perspective, is when there is no escalation mechanism, and thanks to the wonderful services of Amir and Robert, you open the door to entitlement as a contractor. You then have to actually, once you've got that door open and you're saying, okay, I'm entitled to escalation costs, if there isn't an indices or a mechanism in place, it can be extremely challenging to then demonstrate these costs if you haven't been keeping records, as Rob says. So you can, there's several sort of points that you can look at. You can suggest that you do it by published indices, and that might be the most non-administrative way of approaching it. And if you don't have records, it might be a good way out of it. But if the other side is like, no, I want to actually demonstrate actual costs, then you're going to need the right records. And that can be very complicated. You need to have, I would say, from the tender stage of the project, you need to go and demonstrate how you built up your tender and what cost data you use. Ideally, you want to demonstrate that you went into the market and checked the market and you have contemporaneous records, because that's going to be very, very difficult to counter. And then you need to actually document the actual costs incurred. And the other thing that you need to demonstrate is the timing of when those actual costs are incurred as well, which is important. And that can be a challenge for the very reason that Rob brought up, that if you procured this stuff ages ago and you've got it sat in the yard and then you think, okay, I'm going to use that on that project, that would be a real challenge. So these are some of the key things that you need to talk about when you demonstrate costs. And I'm sure Amir and Rob will have some comments on this from their perspective as well.
Yeah.
Sure.
Thank you, Julian. It's really the market is having challenging times, and these issues obviously needs to be reviewed from market dynamics, contract issues, and obviously from a legal point of view. And local jurisdictions play a very critical role here, and it's very important to understand the law dealing with this topic. And I will give the word now to Amir and Robert to see how things go in United Arab Emirates, and also from a common law point of view and civil law point of view. And we already have questions coming from the audience, and I have a few questions sitting here, and they are very typical questions which many contractors and employers face these days. So we will look at these questions in a bit. So Amir, Robert, how do you see issues from a legal point of view?
Sure. Thank you very much. So the starting point, whether you are operating within a civil law jurisdiction or a common law jurisdiction, is your contract. It's a very obvious point to make, but that is the starting point. What the parties have put into their contracts in relation to price escalation, if anything, will ultimately, whether you're before most courts, certainly if you're before international tribunals, or you're having the matter determined by an expert, will be the place that they look to first. Oftentimes, though, and this is, I suppose, when Robert and I get involved, either the escalation clause or the relevant provisions do not exist, or they are uncertain as to their applicability or their methodology. Julian's point as to these contracts, these provisions being very complex at times. So as lawyers, obviously, you'll see on the slide, we always say don't panic, because it might be that your contract doesn't address the issue, but the applicable law will. I'm going to just run through some of the provisions as a matter of UAE law. What I will say is that ballpark, with some minor wrinkles, the same position is true in Saudi Arabia, where we do a lot of our work. You need to look outside of the contract to the relevant civil or commercial code dealing with the issue. The starting point is always unhelpful in the sense that it seems rigid. Article 887 of the UAE Civil Code makes it very clear, and I'll just summarize it, that where you have a lump sum contract and some form of increase arises, then that is your tough luck. you can't look beyond it if you bid it as a lump sum contract. Now, I want to make an important distinction here, and that's between the increase to the price of materials, which you have priced in the contract as a unit price, as part of the overall contract. That, unless you have a way out, stays the same. It's to be distinguished from contracts where there's a remeasurement element. So where you're talking about quantities, not the price of the unit. Remeasurement contracts, completely different ball game. I'm not going to touch upon them. So that's the starting point if you have a lump sum contract under UA law. If we can go to the next slide. There is some hope, though. And in the first instance, the hope is if you can show that the scope of work has changed materially, i.e. more work needs to be done, you can clearly get money for the additional work. Now, that might be through prolongation costs if there are delays as a consequence of extra work, or it might simply be through variations or changes, change orders, for example, issued by the owner-employer. Again, that doesn't touch upon the issue of the work stays the same, but due to inflation, the price of materials rises and therefore the cost to your pocket rises, and you want to at least try and pass that up the line to the employer or try commercially to share it. So this provision won't necessarily help you. If we go to the next slide, you'll see that now we get into a bit of a difficulty, because you have articles 888, 889 of the UAE Civil Code, and they say that where the price of works have not been agreed, contractors shall be entitled to fair remuneration. Now, that's fine if you haven't agreed the price of the works, but you can have situations where you have partially agreed the price of the works, or you fully agree the price of the works, but you want to run an argument under this provision that you're entitled to an increase to the cost of the materials. And I've seen that done. Typically, it fails because this provision is not there to allow you to get a hike for increased price of materials due to inflation. But you'll be surprised how many times I've seen this run through disputes. If we go to the next slide. This is everyone's favorite. It's been everyone's favorite for the last 3 or 4 years. Force majeure, Article 273. I think as a group on this panel, we have probably seen more bad claims being brought for force majeure than good ones. Certainly during COVID and as a consequence of it, COVID has been taken in isolation, or inflation has been taken in isolation, or something else has been taken in isolation without a proper understanding of the context. So it might be, going back to my previous point, the price of materials has gone up. But that might be your fault for sitting on your hands and not procuring sooner. It might be that you've been hit by some other event, but it might be that it's not just a singular event. It might be 2 or 3 events. And how then do you attribute the increased cost to you and seek to have those compensated by the owner-employer? I don't think there is a next slide, but Robert, if you can just flick on. There is. So this is simply saying that Articles 886 and 889 are non-mandatory. So they don't apply necessarily unless you put them in your contract. Article 273, force majeure, is mandatory. Now, that was a very quick run through these provisions. The takeaway point, though, is this. These provisions, you can talk about them for about an hour each. And I think by the time I get to that point in time, the 107 participants will probably whittle down to 2. The point is that you need to look at the applicable regime and try and find the provisions across the civil code, see how each of those impacts your contract, your written contract. That's the civil law jurisdiction. The common law jurisdiction is obviously very different, because if you take England and Wales, where Robert and I trained and are admitted, amongst other places, you have a body of jurisprudence. Jurisprudence provided by the courts to which you can turn that will inform the interpretation or construction of a contract. You have concepts such as reasonableness, foreseeability, how will they impact the allocation of cost if there's a disagreement. Good faith is not accepted as a matter of English law, except in the performance of a contract. So you have to perform your contract in good faith, but there isn't an overarching principle as a matter of English law or most common law jurisdictions that it would be unfair for you to bear the cost as the contractor. That's far more a continental European concept. Before I moved to the UAE, I used to work in Paris. And a number of the contracts we saw were governed by French law. And those contracts typically would import principles of good faith. That's a very high level run through some of the legal principles, but very basically, look at your contract, look at your applicable law. If it's civil law, look at the commercial and civil codes. If it's common law, look at the case law.
Just to carry on for just a couple of minutes on the topic of the law, I think, as Amir said, the starting point is do not panic. And what happens if you are in a situation where you do end up having a dispute, I think is important for us to just touch on very briefly here before we go to the questions from the audience, because I think that is kind of the end of the story if we take this process through its life cycle. And look, as we're all aware on this call, international arbitration is probably the home for the vast majority of high-value construction disputes, and it is the home for high-value construction disputes for lots of very good reasons. But parties have, over the course of the last 10 years or so, become increasingly frustrated with the process, principally because of the cost and the time. No one wants to spend 24 months delving into the issues to get an award down the line that may be an unsatisfactory decision. And so to respond to this, I think what we've seen increasingly in this part of the world, but also in the Eurozone and in Asia, is international arbitration centres changing their rules and bringing in processes to make the process more efficient, more streamlined. And so there are processes now for the appointment of an emergency arbitrator, for fast-track procedures at most of the leading international arbitration institutes and in their rules, which can assist in the circumstances that we're talking about. So I think that's important just to be generally aware of. We also can't get away from the fact that there is still a lot of construction disputes that find their way into national courts, and national courts can be perfectly suitable places for disputes to be resolved in. And in this part of the world, we also have the benefit of having onshore and offshore courts in Dubai and in Abu Dhabi, where we can get the benefit of a common law jurisdiction in the offshore environment or a civil law jurisdiction in the onshore environment. And what that gives is an element of choice where you can look at the differences between those two court systems and pick and choose. And one obvious benefit of, for example, the DIFC court is the specialist judges that they have and the specialist technology and construction division that they built and created in 2017, which was very much modeled on the same division or the equivalent division in England. And that has worked very, very well for the resolution of complex construction disputes, because you get access to specialist judges who can resolve these disputes in a very efficient way. You've also got to be aware that in a court system, you've got the benefit of interim relief that you might not otherwise have direct access to in an arbitration environment. You might get it, but you might ultimately need to then go to a court to get the support of a court to actually use it. So that, I think, is just important from a high level perspective to think about. There's lots of choice, and really, if you are new to a jurisdiction, particularly this jurisdiction, it's important, I think, to sit down with lawyers such as Amir and myself to go through the options and decide whether it is international arbitration or whether it is court, and then what of those various options you should really be considering, because there's lots of pitfalls, and you really do want to be making an informed decision. So that, I think, probably sums up the legal piece and leaves us to now deal with the questions, and I'll stop sharing the screen.
Yeah. Well, thank you. Well, it's a fact. I mean, because of the inflation, and as a result, we experience a lot of disputes in the market currently. And whether it's going to be resolved via amicable settlements or any alternative dispute resolution mechanisms, we will see. But it's a fact in the market that disputes are booming because of inflation. So we'll talk more about what to do in case there is a dispute. But looking at the future, Julian, Robert, Amir, what do you recommend to the parties who are getting ready to sign a contract as of today and negotiating a contract at tender stage? From recommendations from legal point of view, and Julian, from constructability and claims point of view, what are your recommendations, Julian? What do you recommend to a party negotiating a contract? They need to have an escalation clause, I mean, the records. What do you recommend?
Rob, Amir, do you want me to go first and then you guys follow behind?
Yeah, sure.
Yeah, so I think just taking a step back, it's always good to try and be as practical as possible. I mean, most clients, and Rob makes some really good points. The most important thing to a client is generally that they get the project done on time. Obviously, they'd like it within budget, but a lot of projects have knock-on effects if they're not on time, and have consequences to the ultimate owner of that facility. So I think, the conversation needs to start with the fact that this is a global issue. It's you as a contractor cannot say you're not aware of it. So you're in a much better position if you put it on the table and say, this is a real problem and we're facing challenges with it. Again, I think, there are set clauses, there's set contracts, there's set mechanisms that have been tried and tested through the courts, which you can use and are out there. I just think from a commercial perspective and an estimating perspective, you need to be very careful what you're signing up to, and you need to look at break down the construction of the works into where you think the risks are, where there's a lot of movement in the market. And what you've seen. The problem is that you can only see what's happened in the past, and you don't know what's going to happen in the future. And so you do need to sort of think that through and think about what happens if a certain part of the work just goes up astronomically. And you can deal with that through drafting, you can deal with that through mechanisms. I think as well, what I said to one client recently, he was extremely worried about a certain element of the work, and it was very, very difficult to get a profile on the risk. And I did say to him, well, maybe you don't go with an escalation clause on this particular item. On this particular item, you almost do it as a cost plus, and you just say, this is, for this item, I will, the costs will be what they will be, and then there's a markup on top of it. And that way, and I think employers and operators are open to this, and I think it should be brought to the forefront. Rob, Amir, I'm sure you guys.
Look, I think some of your thought processes when you're looking to bid for work and when you're out winning work will largely depend on where you're doing it and the market you're in and the competition that you've got. Because take Saudi Arabia for example. Julian, Amir, and myself we spent quite a bit of time in Asia, and last year we were all together in Seoul speaking to Korean clients. And they repeatedly talked about being underbid for work by Chinese contractors in the Saudi market. And so they talked about that in a great deal of detail and the impact that was having on their bid processing. And that was just because it was a race to the bottom. So it really does depend on who your competition is and the market that you're looking at, and you will have to adapt. And so taking an approach that you would take for the Turkish market or the Eastern European market and trying to model that and develop that for a Saudi market, for example, or a Eastern African market is not going to play. I think from a practical considerations perspective, as Julian has said, you really do need to kind of get these issues on the table from the outset. I think it's really important to continue to look at it. It's not just to look at it once and then, oh, it's done, or look at it once, have a conversation, be knocked back, and then it's done. I think you ultimately have to keep it repeatedly under review, because pricing is repeatedly going up and up and up in the current market that we're in. So I think that's important. From further practical perspectives, we talked about this very briefly, that you need to look at your procurement processes as well. And I think you also need to revisit your insurance policies, because that's really important from a practical perspective. Fundamentally, you want projects that are bankable, and in the current market, it's difficult. And so you need to look at all of these things to ensure that you can then satisfy any funders that you've got, that you've done all the things that you need to do.
Okay, let's elaborate a bit more on the insurance policies, because this part of the market, I'm talking about Turkish market, we don't see insurance issues many much on escalation issues. Are you talking about hedging? Just elaborate more on the insurance for our market benefits.
Well, I think from my perspective, with higher prices for material and labor, that's going to ultimately be reflected in the cost of the project. And since those losses will then lead to more expensive rebuilds, the sum insured is going to have to be revised to minimize the risk of being underinsured. And so I think construction insurance brokers and advisors need to kind of sit down with contractors, and contractors need to sit down with them to kind of think about the valuation process, to ensure that appropriate policy limits are put in place. So I think that's where I'm coming from on this. But I think you're absolutely right. Look, from one market to the next, it's going to be a completely different approach with regard to insurance. I'm perhaps coming at this from a kind of a Western European UK perspective, because I'm an English qualified solicitor, as Amir has said, and that will be how they'll be looking at it. But it's fair to say that there's lots of projects in this market that there are self-insurance. Self-insurance is a massive thing in this part of the world, and so it's not even a consideration. Big state contractor, semi-state contractors will go in, and it will just be done on a self-insurance basis, and so it's not a consideration at all.
Thank you. Well, before I give the word to Emir and to get his views, so Emir, from a legal point of view, so if you give your comments on my previous question, how should escalation clauses be drafted in the contracts now, looking at the future? Also, can you say your views on that?
Sure. So,
but I'll tell my view from practical point of view. I mean, if you have a contract, usually the employers come with a standard clause, and there is a formula in it with coefficients. Okay, and then you negotiate at the time between employer and contractor, and you arrange the coefficients. Okay, steel is so much percentage of the total cost of the project, and insert a number in the formula. That's how the market used to do it. So, what's your view?
So, I mean, that is the traditional way of doing it. The issue, though, is that it's very difficult to draft an escalation clause that captures all of the potential increases to price. You end up, and you can do this. I mean, we have some contracts that we've drafted for clients where you end up with a really unwieldy escalation clause with various references to appendices and different formulae to assist the parties. Usually where I start with the legal approach to these types of contracts is to look at the worst case scenarios. Often parties do not do that. It's that old maxim of agreeing the principal provisions and then sticking in a bunch of boilerplate provisions at the end, force majeure, dispute resolution, without any real thought as to whether they are right for the contract or not. I also advise, and this is not a self-serving statement, although it will come across as one. Typically what you have when you are negotiating and then concluding contracts is project counsel on board. Project counsel are sectorally very experienced. they are transactional lawyers, and they will look at things from a particular vantage point. If you imagine the amount of money on these projects that will be incurred, having the benefit of a litigator review your contracts in draft during the negotiation process before they're settled can save millions of dollars down the line. So you have someone who looks at it just purely from a perspective of, what if everything starts going wrong? Where does the risk lie? Has the risk been allocated? Take those into the negotiation room. At that point in time, it's perfectly valid to do that, because what you're saying really is, we want to avoid a dispute. We want to make sure that whatever happens, whether it's price escalation, is dealt with within the four corners of this document. So that's always been my starting point to clients. Usually it's after the event, because they come to me with a dispute. My first thought, I don't express it, because if I express it too many times, they would never come to me again, is you should have had me look at this before. I think if you approach it that way, you can then break down the various risks and see if you can address them contractually, whether it's through an escalation provision, some other form of indemnity, whatever it might be under the contract.
Yeah. All right. Well, thank you for all the views. And I think we can go to the fun part now. I was going to ask a more specific question, but I see the audience already asked the question I have in mind. So let's take this question. I will read that and we can all share our views. So, and I asked the audience and the attendees to use the Q&A box on the bottom of the screen and to ask their questions, so that you can keep your names and company information obviously confidential, and type your questions here. So we are here to answer. So we awarded a contract by end 2020, including a detailed escalation clause. So that's over 2 years ago. So material escalation is based on certain indexes. However, manpower escalation is based on preset calculation. So it's a fixed percentage annual increase. So the problem is, due to dramatic increase of inflation during post-award, there is a gap between inflation and manpower escalation. So can the contractor claim in this regard? And I'm sure many attendees today have a similar experience. So we do, I know, as panelists. So what are the views here? So who wants to go first and say a few words?
Yeah, do you want to go first, and I'll follow up behind you?
Yeah, sure. So the question is beautifully phrased in the last sentence. It asks, can or should the contractor claim in this regard? The answers might be different there. As to should, yes, because what is the harm in doing that? So yes. Can is a little bit more difficult. Strictly speaking, if you have a manpower escalation mechanism based on a set calculation that the parties have signed up to, it will be difficult to suggest that a different approach should be taken when it comes to seeking the additional cost. So the starting point will be tough. There might be, depending on the applicable law, arguments as to whether, one, the manpower provision is still right for purpose, given changes in circumstances, and you would have to argue those changes in circumstances. That's not a particularly attractive argument as a matter of law, because most jurisdictions would answer that question by saying it doesn't matter. The second argument would be around, well, if you were in continental Europe, you would have arguments in equity, whether as a matter of equity, it is fair and just for the contract to be held to a provision that is so now out of sync with the reality on the ground. So there are certainly arguments that can be made. So yes, you should make the claim initially softly, Two, will you prevail? It really depends on what else the contract says and how robust you can be in terms of other circumstances impacting the fairness of holding the parties to that particular provision.
I think I would, and I agree with everything Amir said. It's very well put. But the other thing that we've experienced is also to have a look at the facts around what's happened on the project. I think this is really important to understand how the progress has been on the project. Has there been any variations? Has there been any delay? Because it's possible, and I don't know, we would need to understand more of the facts around the case, but it's possible, based on my experience working with Rob and Amir, that if there's some facts around the project being delayed or maybe the work being varied, you may be able to recover some. It may be a challenge to recover all of it, but there may be some way under either the variation or extension of the project to be able to recover costs related to this. So it's very important when you have an issue like this that you really understand, what has driven it. And it may be more than one thing. It may be that, yes, you signed up to this clause, you're kind of locked into it, it's a bit of a challenge. But as the project has moved, certain events have happened, and you may be able to recover some of these related costs through those events.
All right, thank you for this. Well, I'll go to the next question here. Okay, well, let's read together. How does the funding security of mega projects, especially the ones financed via taxpayer money, approach to this? What if the client goes to payments, security, and insurance agencies to increase funding of an industrial plant project? So it's from more of a finance point of view. So what are your views on that one? Who wants to go first? You can all read the questions, correct? Julian, Robert, you can see the thing.
Yeah. But I think there's an overarching point that's probably quite obvious, but worthwhile making, that funders, whoever they are going to be far more cautious when offering funding to projects that are high value, that are complex, and that have a long building time. So I think that's the first point. I think the other point is it really depends on where we are and the part of the world that we're talking about. I think the approach in the Turkish market will be very different from the approach in the GCC, Saudi Arabia, the UAE, the wider area, and that will be very different from the approach in Asia and the approach in the UK. So I'm not sure it's possible for us to give a straight answer to the question, unless Amir and Julian have any other thoughts. But I think it's a difficult question, and I think in a true lawyer's response, it depends. It depends on an awful lot of different factors.
Yeah.
I mean,
well, go ahead, Amir. Yes.
My main observation is it depends on the initial compared to the subsequent funding arrangement and terms. So there's a point made initially that the funding is via taxpayer money. That will come with various constraints. There might be issues. I mean, I know the question poses, what if a client goes to payment, security, insurance agencies to increase funding? But it might be that's simply not possible because of the constraints imposed by the first lender. It might be the case that the second lender doesn't want to take a second priority position in terms of its funding to the project. In principle, there is nothing that would stop this type of layered funding. We've certainly seen it with some projects, that tends to be a form of almost emergency or bridging funding, often is in scenarios where there's some form of distress. But if I've understood the questions correctly, it is possible to do this. I'm not sure it necessarily has an impact on escalation unless you're funding specifically in order to meet the gap in the treasury caused by price increases. But that in itself is fine. There's certainly no legal impediment stopping you from doing that. It's a matter of whether you can obtain the funding.
Yep. And for finance authorities to make the payments, another authority needs to give the approval based on the contract and on the legal. And I think quick and fast and solid dispute resolution mechanisms are also key at this point, because we see many projects in the markets, unfortunately, who are suspended or close to termination because of this price increases. So if the parties cannot come to an amicable settlement, then dispute boards, mediation, fast arbitration is important to solve the dispute between the parties. I think that's also important. Anyone else? Yes,
I was just going to add, I think, just my experience from talking to people that are funding projects, or the ultimate owners or employers, that there is increasingly a side on their budgets that they are starting to allow contingency for this, and I do think that's sensible. I'm not sure if anyone in the audience is from that side, or we're mainly dealing with the contractor side, but definitely I had a conversation recently about where someone was looking at the overall cost of a project, sort of an early sort of feasibility phase, and this is now something that people are building into that financial model, which I think is very sensible, and I think that can help avoid these funding issues, because let's face it, all the data is telling us that it's going in one direction. So if you're not allowing that in your cost model or funding model for the job, it's a bit naive. And I think you should be putting contingency in there, that it's very difficult to get this absolutely right, and by having some contingency in there will help you sort of manage the issue a bit better.
Yeah, absolutely. I think that's very key. Well, I think we can take one or two more questions, and I have one questions that was delivered to me via text message. Well, let's talk about cost and damage calculations. Let's say we have the contractor and employer are willing to come to an amicable settlement for accepting the additional costs as a result of price escalation. So the project started in 2020-21, and you are 2 years into the project, and the contractor faced additional costs. So as of today, how do you calculate the damage or the cost and pay to the contractor if you are an employer? So you will have costs looking to the past retrospectively, and also the contractor is asking costs going to the future, assuming that the cost will be increased. So how to deal with that? I think there's more of a question maybe to Julian from
I think
point of view, and we can have the legal view later.
Yeah, no, I think my two esteemed legal colleagues will definitely jump in on the future costs, because that's an interesting point. But I think I talked about it before, and I'm talking very much about demonstrating the escalation cost. So if there's no mechanism, you're going to have to demonstrate the cost that you've incurred, and that the way I've done this and approached it is you have to go back to the tender, and you do have to break that down and demonstrate what you allowed in that. And that's why I'm encouraging contractors and clients at the moment to really have a lot of detail around what's happening in the market and what the tender is based on, because that is your benchmark. And without being able to demonstrate that, you're going to get into issues. And I'm sure Amir and Rob will cover that. But you need that base point of, okay, this is what I allowed in my bid. This is what it was based on. This was where the market was. That's your base. Then you need to look at what you actually incurred when you procured it, which should be reasonably straightforward because you've incurred it from a supplier. There should be paperwork and it should all be documented and all that kind of thing. So in simple context, that's how you demonstrate it. Your question about the future, you know, the issue is that you're not actually, so from a damages point of view, there is no damage at that point. And I'm sure Amir and Rob will cover this point. Now, if you're in a position where you're 2 years in and the other side have come and say, we want to resolve this issue and we want to close it out, you can demonstrate your cost model going back, saying this is what I've actually incurred. You're then going to have to look at where the market is at the moment. And what I would suggest is say, well, this is what I think it is for the future. And you probably better, rather than taking it, because if you close the issue and get it wrong, you're not going to have much recourse. So going forward, what I would suggest is you could build up an estimate based on what's happened to date and where you think the market is going to go, and then probably revisit that at the end based on actuals, and you would need to demonstrate. I think that's probably fair and reasonable. If they want to close it out and they say to you, we want you to take the risk on this, we understand you've incurred these damages to date, but we don't want to revisit this and going forward, we want like a lump sum and it closed, then you would need to build in a risk profile of what you think would happen, but you're going to close the door on it. And if you underestimate it, then there's a risk there that you'll lose money in the future. That's from the cost modeling, but I'm sure Amir and Rob will add from a legal perspective on it because it's an interesting question.
Yeah, Julian, the answer from a legal perspective is actually very similar, if not exactly the same. So in order to make good a claim for costs, you need to substantiate the costs. That is the basic position. In relation to past costs, historic costs, that is subject to record keeping and or other data that informs the cost incurred, the damage, relatively straightforward because you're dealing with actuals. In terms of forward-looking costs, at that point in time, from a legal standpoint, damage has not yet crystallized, and therefore there is no entitlement. It then becomes a non-legal issue, which goes to your point, Julian. It's more a commercial assessment. The parties may wish to agree a sum for future damage or cost and settle that number. I entirely agree with you. It is much better to leave it open for a final accounting because it's almost the concept of remeasurement, right?
Yeah.
You have an estimate of quantities and you remeasure it depending on the actual used. Well, estimate the damage going forward and then reassess it at the final account and close it up. But there may be very good commercial reasons that the parties don't want to do that, particularly the party that wants the money, because they may be pushed down to accept a lower number sooner, and that cash flow can be king.
Yeah. All right. Well, okay. Any other views on this? Because this is really the top issue and hot issue on the market right now. Because even if you want to come to an amicable settlement, you need to quantify it and how to do that. And if you, as Julian and Amir said, I fully agree. I mean, looking retrospectively to calculate the damage is maybe sometimes easier. So if you look at the records, you can come to an agreement, but how to handle the future? Parties may choose to agree on an escalation formula to enter into the contract to cover the cost to the future. And I think employers and contractors, they both need to understand that this escalation formulas, they may be an additional cost or it may be a deduction from their pay estimate. So I think it can be considered as a fair solution looking to the future to have an escalation formula reinserted into the contract or having an additional agreement, a side agreement to eliminate the risks of inflation. All right. Well, I think we don't have any other questions, but I have a list of questions which I want to cover. But I think we discussed many of the issues today. Any other points that you want to make, and issues that we didn't cover, and you want to say a few words, Robert, Julian, Amir?
All I was going to say is just tied to the point that you just covered. This is going to sound like a hard sell, and it's not intended to sound like a hard sell, but I think what is really important to consider is getting a firm of experts on board early and getting a lawyer or lawyers on board early, because in my experience, leaving it to the point when a dispute has already arisen or an issue has already arisen is often too late. And actually firms of experts and firms of lawyers throughout the life cycle of a project can actually be very cost-effective way of navigating some of these issues as they arise and answering a lot of the questions that you and the audience probably have. Because if you've got these people on board throughout the life cycle of a case, you can get very sensible, measured responses. And that can actually work very well from an employer's perspective, because what it can do is it can help you present your claims in a way that an employer can actually deal with it and come to a resolution throughout the life cycle of a case. So it sounds like a hard sell. I'm not advocating these two firms, although I am. But what I would say is, in our experience, at least, working together is that firms such as CCI and law firms such as Kafaria Partners throughout the life cycle of a case is very helpful.
Yeah, and I echo Rob's comments, but I would also add to that I personally think this is an issue that's not going away. And as whatever your business is, whether you're a developer, whether you're a contractor, you should have a strategy within the company of how you're going to deal with this. And so, yes, we can get involved on individual projects, but I think the three of us as well are well equipped to deal with a more strategic approach as well. And being honest with you, I don't think it's project specific. I think it's across your business. So it's probably better to look at it from that perspective and understand how as a business you can protect yourself, what you can do. And again, I think unfortunately we see all the back end problems or the issues. If you take that knowledge and put that into the business, I think that's a great way of doing it. And we have done that with some clients, and I think that's the way to really deal with it.
I will make one final and very short point, if I may, which goes more to strategy and what we see in this part of the world, particularly in jurisdictions such as Saudi Arabia, where we and Julian do work, and our firms are currently engaged on a project there with one another. There is a real sense of nervousness from the international contractors to escalate or take robust positions against state-owned or quasi-state-owned owners or employers. They take the view that if they're too aggressive, they will somehow be blackballed down the line on other projects. That is simply not true. The opposite actually applies. The more robust you are, the more likely you will actually come to a commercial arrangement with them. And often, in my experience, very sophisticated contractors take the view that they are the one that is suffering, but they don't look to the project. The owner wants its project completed. If as the contractor or group of contractors or consortium or subcontractors, you are suffering financially and you cannot complete or meet deadlines, that is going to impact the project. You can use that as a lever, and often they don't. That works very well in this part of the world.
Yeah, all right. Well, my last words is I will make a brief reference to FIDIC's Contracts Committee's a memo issued last 2 weeks ago. And FIDIC usually doesn't issue memos, commercial type memos like this, but it basically says contractors, employers, suppliers, investment agencies, we all need each other. And this is a big dispute these days, price escalation and inflation issues. And they say we need to find a solution as a market to this. Just don't look at the contract only. Look around the corners, look to the applicable law, and try to find a solution for the sake of the economies and for the markets. So I'll urge the attendees to read that memo, and if you don't have it, I'm sure you can find it on the FIDIC website or email to SCL Turkey, and we'll issue it to you. Well, I want to thank Julian first and CCI for assisting SCL Turkey for this conference, and Amir and Robert, Ghaffari partners, to give their time to attend this webinar. We can discuss another 10 hours on this specific issue, but we said we will cut around 1 hour, 15, 20 minutes. Thank you very much for joining. Appreciate it. And that concludes our webinar today. So thank you very much.
Thank you. Cheers.
Thank you.